is it supplementary?
Supplementary cost list, item number 1.
Please, Your Lordship. As on today, 27 days in custody, Lordship. You'll kindly find the FIR in Annexure 1, page 15.
Yes, sir.
The incident.
The case diary was called for. You, what? You have this CD.
My very humble submission before Your Lordship that by this time all the FIR named accused has been arrested, Lordship, and the statement of the informant has also been recorded. Perhaps the investigation has reached in such a stage where his further custodial detention may not be required, Lordship. Rest all the matters are to be decided in the trial, whether the incident took place, did not happen. These are all matter of trial. And he, Lordship, he is highly sick. I don't know whether the report has been called for or not, but he is presently in the civil hospital under Nampu, under the judicial custody. And he is highly diabetic, Lordship. I have given some documents, Annexure 3, page 18, are his medical documents. And as Your Lordship will kindly appreciate, being a diabetic, he is required to be in diabetic diets, which are little bit difficult, and in fact he is not receiving, although in hospital he is receiving some sort of insulins, but not the one which he is used to take regularly.
Yes, Mr. Please. What is your submission?
Your Lordship, as directed by Your Lordship, we have just received the CD and Your Lordship.
Yes, tell me. You have received the CD, you have gone through the CD, so tell me, what is your submission? Are you opposing the bail or not? Or what is your ground if you are opposing it or otherwise?
My senior, Mr. R. Guru, is leading the matter. However, kindly give us some time for him to appear and argue the matter.
In that case, if they are seeking adjournment for
No, we will take it at the end of the board.
end of the diplomat.
Read cost list, item number 2.
Yes, Mr. Pathak.
My Lord, these were this pay commission issues. We had already submitted one written argument, and the issue otherwise, my Lord, has already been decided to a large extent by the division bench.
No, Mr. Pathak. If you recall, on the last occasion,
Yes.
you said that there is a pending, SLP before the.
Yes,
So,
yes, my Lord.
Which
That
will
should
have
be, my Lord.
which will have a bearing on this case, or
My
do we decide this independently?
My Lord, SLB is coming up on the second week of May, my Lord, as I am told. It came up on 17th of March. It's now fixed in the second week of May. My Lord, we may wait for some time at least, maybe, if that be so.
That is for you. You are the petitioner.
My Lord, my Lord. Otherwise, the Union bench has, my Lord, already held that entitlements as per Fifth Pay Commission are to be given, my Lord. Exactly how it is to be worked out, what benefits are to be given, my Lord, it is for the respondents to work out.
So, according to you, we will wait for the outcome
Because yes, in the division bench judgment, my Lord, our trade vehicle mechanic was also, my Lord, there. Some petitioners were there, my Lord.
Because if I understand correctly, the special leave petition would cover not only this issue in particular, or not only the issue raised in this petition, but perhaps other issues which were there, in other matters which have already been decided as regard the personnel of Assam Rifles, isn't it?
My Lord. Yes, my Lord. So we can have it in the third week of May, my Lord.
Fine. Mr. B. Pathak, learned counsel for the petitioner, has submitted that the special leave petition on
It's 11 o'clock.
dealing with similar issue as is present in this petition is yet to be disposed. In fact, the matter has not yet been heard by the Apex Court. As submitted earlier, the outcome of the decision of the Apex Court would have a direct bearing on the issue raised by the petitioner herein, and accordingly it is submitted that it is prayed that this matter may be taken up after when is the matter before the Supreme Court, you said? First week?
My lord, second week of May, my lord. So we can have it in the third week, my lord.
Fine. In the third week of May. Accordingly, list this matter on 18th May. So 18th. Thank you.
Item number 3.
Your Lordship, let this matter come up after 4 weeks.
Why?
After 4 weeks, Your Lordship. Your Lordship, Mr. Philemon Nongri is having a personal difficulty.
My lord, Mr. Nongri, on the last occasion or so, my friend has submitted that his immediate relative is quite critical. So his situation has not improved. So he is attending him. So my lord, it's been difficult for him to come to court. He has also informed me, so my lord. So I do not have any objection on this.
Prayer for adjournment has been made on behalf of the petitioner on the ground that the learned conducting counsel is facing personal difficulties and could not attend court. On the prayer not being objected to by the learned counsel for the respondent, the matter is adjourned. This is same as prayed for. This is same after 4 weeks.
I oblige, Lordship.
Item number 4.
May it please, Lordship. Lordship, if this matter may be taken up at the end of the boat. My senior is currently engaged in other court.
Fine. End of the board.
Item number 5.
Item 5 is connected matters.
4-5.
Item number 6.
Your Lordship, on the last occasion, the petitioners had stated that they want to file an affidavit, but we have not received any affidavit as yet.
No, on the last occasion, I think a new counsel has appeared on behalf of the petitioner.
Yes, Your Lordship, he entered appearance on the last occasion.
Apologies, my lord. My lord, here on the last occasion, I filed my wakalatnama.
Yes.
My lord, I had requested this honorable court, my lord, if I am allowed to, because earlier occasion no rejoinder was filed to the counter affidavit filed by the Union of India, my lord. My humble request, my lord, because after going through the, my lord, the affidavit in opposition, I have realized, my lord, a rejoinder will be necessary.
See, Mr. Bhattacharjee, it's a 2017 matter.
My lord, only thing is that I have entered appearance on the last occasion.
Mr. K.P. Bhattacharjee, learned counsel appearing for the petitioner, has submitted that he has entered appearance on behalf of the petitioner only recently, and on perusal of the records, particularly the counter affidavit filed by the respondents, it is deemed necessary to file a rejoinder to the same, which was not done so earlier. It is therefore prayed that this matter may be, that the rejoinder may be allowed to be filed and the matter to be heard on merits. On consideration of the submission made, it is to be noted that this is a case of 2017 and considerable time has passed with the parties not being able to conclude the argument. The prayer of the petitioner, however, may be considered for ends of justice. Accordingly, the rejoinder is allowed to be filed. It is, however, made clear that no further time will be allowed for the rejoinder to be filed, and if not filed on the next date, or the next date fixed, the matter will be heard finally. How long?
My Lord, if kindly allows 3 weeks or 4 weeks, my Lord, so that I do not fail. My Lord.
As prayed for, this matter to 4 weeks.
Item number 7.
Please, Your Lordship.
Yes.
Your Lordship, the conducting counsel is on leave, Your Lordship. I pray that the matter may be fixed on next date, Your Lordship.
2018 matter. What is this matter about?
It's a CBI matter, my Lord, under Section 480 CRPC.
Yes, what are the facts?
It is for quashing criminal proceedings, Your Lordship.
Prayer has been made on behalf of the petitioner on the ground that the conducting counsel is indisposed and could not appear before this court today. The prayer has not been objected to by the respondent. Accordingly, matter is adjourned. List the same after 2 weeks.
Your Lordship, similar prayer for item number 8 and 9 as they are related matters, Your Lordship.
8, 9, same order.
Much.
Lordship, I'm appealing for number 4, my lord. As per the last order, I was required to file a corrected affidavit, my lord. I believe it has been in the course of filing, my lord.
Corrected affidavit in what?
Some name and the name of the king and all were, my lord, misspelled in the affidavit, my lord.
Okay. But that is the crux of the matter, isn't it? The name.
content,
The
otherwise
name,
is-
Your
the
Lordship.
name is
the
the
name.
crux of the matter, my lord.
Just the name, Your Lordship.
Yes.
The certain they have committed an error in.
Yes, I now I recalled it.
Last occasion, the court did not sit, my lord. So today we are filing the affidavit and taken up for hearing, my lord. We have not brought any additional, my lord, facts. Only the name has been changed of the deponent.
Have you done it?
Yes, lordship. It's in the course of filing.
You've given him a copy?
Hands.
You are for?
Respondent 4, lordship.
Respondent 4. Mr. Legal Counsel for the Respondent 4 has submitted that the affidavit required to be filed before this court for which certain portion of the have you filed an affidavit earlier?
Lordship, what happened in the original affidavit, the name of the deponent and the name of the akin was wrong, or some typographical error. So only to change the name of the deponent and the name of the concerned akin, Lordship.
For which certain correction are required to be made, particularly with regard to the name of the deponent and the name of the Aking land is being filed in course of the day, and accordingly accommodation is sought for this matter to be heard on the next date fix. How long?
2 weeks, Your Lordship.
3 weeks?
2 weeks.
As prayed for, let's just matter up to 2 weeks.
Item number 11.
Any private respondents?
No.
No. Yes, Mr. Nokla, please start.
May it please Your Lordship. Lordship, the petitioner has been appointed on compassionate ground on the 16/6/1994, Lordship, after the death of her mother, who was serving in this forest department of state of Meghalaya. Lordship, thereafter, she has been serving for the last many years without any adverse remarks or against her, Lordship. And Lordship, what happened is, for the last 22 years, she has not been approved for appointment, Lordship.
What was her initial appointment was as a contractual?
LEA, yes.
No.
Lordship.
Was it contractual or what do they call it?
I'll just read the appointment, Lordship.
Let us have a look at the.
Annexure.
Okay. Appointment on compassionate ground means it's a permanent appointment.
It is a permanent appointment, Lordship. And
on that, in that category.
The department disputes that.
Oh, you refute?
Yes. Anyway,
okay.
Appointment, Lordship, appointment annexure 2, I may be allowed to read, Lordship.
Annexure 1 or annexure 2?
Annexure 1, Lordship, sir. Type copy is there.
Yes.
Subject to discharge without notice and assigning any reason thereof, Srimati Degres Basayumait, daughter of so-and-so, ex-LDA, PCCF's office, who died in harness, is hereby appointed to the post of LDA on compassionate ground in the scale pay of such and such pay, plus other allowances as admissible in the OO, the Divisional Forest Officer, East Kazil District, Shillong, with effect from the date of joining. Srimati MC Sohn, LDA, promoted to the post of UDA. The appointment is purely temporary and subject to the government approval and good police report. Lordship, though the appointment is temporary, Lordship, but she has been approved only after 22 years, Lordship. Only she has been approved only on the 2nd March 2016, Lordship, without any reason thereof as to why it has been taken so long for her to get the approval, Lordship. And while as, Lordship, the other employees who were appointed on compassionate ground few years after her, they have been promoted, Lordship. But
so she was in the same post for
Lordship, up to
for
date.
20 years or so.
Yes, Lordship, same post. She has not been promoted. And but other employees have been appointed after her on compassionate ground. They have been promoted, Lordship. And in seniority list also, they have superseded her. Okay. So, Lordship, we have filed petition after petition, but then no thing has been considered from the government side, Lordship. And then even the ACPS also, she has not been given, Lordship. And in this connection, Lordship, I would rely upon ruling AIR 1990, Lordship. Page 1608, Lordship. I have put a flag over there.
Para.
I think it's para 7, Lordship. I'm not second. Page 1608, Lordship, over there. Here it says like this: once an incumbent is appointed to a post according to rule, his seniority has to be.
These are head notes, Mr. Clark. You're reading head notes. Come to the relevant para.
It is relevant, Lordship, because she has been appointed.
Yes, you are reading head notes. Head notes are not authority. They are concise, portion of the actual paragraph. What is the paragraph?
Paragraph 44, Lordship.
Then you read paragraph 44.
16. Here it says, paragraph 44A. Once an incumbent is appointed to the post according to rule, his seniority has to be counted from the date of his appointment and not according to the date of his confirmation. So, Lordship, my humble submission is that she has to be, that seniority has to be counted from the date of her appointment, Lordship, because she has been appointed on compassionate ground as per rules, Lordship. So for the last many years, she has been suffering. I mean, no thing has been, her sanity has been superseded by others, those who have been appointed on compassionate ground itself, Lordship. And now she is still struggling in the same post, Lordship.
She is still in service?
She is in the office, Lordship.
Still in service?
Yes, Lordship. She has got few years left, Lordship.
Okay.
So my humble submission is, Lordship, you kindly consider her plight, Lordship, by directing the respondent to consider her petition.
Yes.
The compassionate appointment scheme right now, it's not available, my lord. I've asked my friend to get it. Nevertheless, my lord. Now, as far as the compassionate appointment is concerned, my lord, there is a certain manner in which the application is to be made by the candidate to the government, appropriate government authority, my lord. And thereafter, within a period of 1 year, then thereafter, the government will take necessary steps for, my lord, the necessary steps will be taken by the government, and then thereafter, the approval will have to come from the Personnel and Administrative Reforms Department, and then thereafter, the appointment is given. Now, admittedly, my lord, as far as the appointment of the petitioner is concerned, the respondent authority who has issued the appointment order, my lord, he is not competent to give any compassionate appointment, my lord. The compassionate appointment can only be issued, order can only be issued by the government, my lord. Because normally what, my lord, this is a sanctioned post. Now, this is an exception, my lord. Otherwise, any vacancy is to be filled up through the selection process, my lord. Advertisement will be made through the district selection committee, and thereafter, my lord, after necessary, my lord, the candidates will appear. Then thereafter, interview, test, all that is there, my lord. Thereafter, selection is done. Now, compassionate appointment, my lord, is only an exception, my lord. It is an exception. However, my lord, there is a certain pattern which has to be followed. Now, whether the authority who has issued, my lord, I may be allowed to read the order, my lord. This, which is a type copy, which is at page 11.
Yes.
Subject to discharge without notice and assigning any reason thereon. Srimati T. Grace Basaimoy, so and so, daughter of late so and so, who died in harness, is hereby appointed to the post of LDA on compassionate ground in the scale of pay of rupees so and so, plus other allowances as admissible. The DFO is Kasih's division, in the office of the DFO is Kasih's division, so long with effect from the date of joining, vice so and so. Now, Srimati so and so, LDA promoted to the post of UDA. So, my lord, there was a vacancy. Now, my lord, even compassionate appointment, there cannot be direct appointment to the post of LDA. Although it has to be a grade 4 post. Although the entry into the service has to be at the lowest rank. Lord, now there is and my lord, this vacancy is created by some staff who was an LDA, who is promoted to UDA, and that vacancy is adjusted. That is not permissible, my lord. The compassionate appointment always has to start from the lowest grade, my lord. Normally appointments are made at grade 4 level, my lord. So secondly, my lord, the authority who has issued, my lord, this order, in a way, it seems more like a temporary nature, my lord. Secondly, the authority who's issued the order, stating that she is appointed on compassionate appointment or not, whether he has the authority or not, he does not have any authority. Whereas vis-a-vis the other candidates, which the petitioner is not has challenged, my lord, however, they are not a party to the writ petition. My lord, their compassionate appointments have been done and confirmation in service has been done only after due process. The posts have been filled up, my lord, when the incumbent, a certain incumbent has died. Thereafter, an application was made, proper application through proper channel, my lord. Then only after approval, their appointments were issued, appointment orders were issued, my lord. So that is a different case altogether. Petitioner's case, my lord, there was never an application made by the petitioner, my lord. Applicant will have to make an application for compassionate appointment in a standard form. There are certain procedures which are there.
But how was the application of the petitioner accepted? If it was not in the
there was no application of the petitioner, my lord.
Then how was she appointed?
Because my lord will kindly see, the petitioner has also not enclosed any application in the writ petition itself.
It was
a clearly straight order, my lord.
It was arranged from the department itself.
Exactly, the petitioner has approached the department, but that is not a compassionate appointment cannot be issued in that manner.
At that point of time, she would not know that she has to apply, if at all. So she was called to the office and then she was given appointment. That's what she was very young at that point of time, also, Lordship. So she would have not known those procedures, Lordship. And then, Lordship, regarding the implementation of order.
Just let him finish, please.
Lordship.
The burden cannot be shifted on the respondent, sir. The petitioner will also have to be aware of her rights, my lord. If it is a question of compassionate appointment, my lord,
But if
because
you
it is
see,
against norms, against procedure, my lord.
whatever the case may be, Mr. Bhattacharjee, if you have proceeded in an irregular manner,
My lord.
would the petitioner be blamed for that? You
Well,
have
the
you have
authority-
issued a appointment order. You
government
have
has
not
issued
rescinded that.
Government has not issued that.
In any case, if the government has not issued, she was functioning in a certain post. If her function or her being there in that post is an illegal, action, she should have been, terminated. Action should have been taken against her.
My lord.
But you have not done that. You have allowed her to continue for 20 years or so.
My lord, the government was informed regarding this at a very later stage, my lord.
That cannot be. That's a very late.
No, my lord, the question remains here, can an authority, my lord, then that will be a question of law, my lord, whether an authority who is not competent to issue such an order, can such compassionate appointment be allowed, my lord?
Was the authority, if the authority per se is not competent to issue the impugn order, whatever. Now, was any process embarked upon to correct that? Because he would not be the ultimate authority. The ultimate authority would be somebody else. So, on noticing this irregularity, has any steps been taken to correct it? Now you are
No,
what
that
are you
is
doing?
exactly why, my lord.
What you are doing is you are instilling some sense of security, sense of hope in the petition for so many long years. At this stage, you cannot do away with that.
My lord, but the appointment order itself says subject to discharge without notice and assigning any reasons.
Mr. Nongklau has also pointed out that eventually her appointment was approved. When was it approved?
Yes, Lordship.
That is there, my lord. That is there, but my lord, her appointment cannot be considered, my lord, her seniority cannot be considered vis-a-vis the seniority of the other candidates, my lord. Their candidature, my lord, has been approved with due procedure, my lord.
But then again,
Just a moment, Mr. Nongklau. Let him finish.
My lord, the petitioner, in my respectful submission, should be thankful that the government has considered, my lord. Now, had the government taken a different view, my lord, that okay, your compassionate appointment not as per procedure, so your service is terminated. The petitioner should consider my respectful submission herself to be lucky, my lord. We have filed an additional affidavit stating, my lord, how the others have been placed and what is the date of their appointment. This is an additional affidavit, my lord, which was filed on 30/3/2023. So all the other candidates, my lord, they have come into service, my lord, through due procedure, my lord. Hers is not the case. The government, nevertheless, my lord, looking at her service at her condition, the government has considered. Now, had there been a contrary view, it would have been a different matter altogether. The petitioner would not have had any right, my lord.
Okay, let us assume that your argument is valid. If you look at the Annexure 2, that is the approval by the competent authority.
My lord, it's very clear.
It says that the appointment should be from the date of approval, that is 21/3/2016. Okay, let's even take 2016 as the basis. Since 2016 till date, was she ever promoted? Is she due for promotion?
No, my lord, the promotion will come because there are other people who are all senior in the, my lord, in the seniority list, there are other candidates who are senior to her.
True. But since 2016, considerable time have passed.
My lord, now promotion will be based on the basis of the vacancy, my lord. And
Exactly.
if there is a vacancy, there is also ratio, my lord. There is a certain ratio which had to be followed, my lord. Certain number of.
Nobody is disputing that process. The only things that the court would like to know, but since 2016 till date, was there any process for promotion? Not only in her case, but person equally or similarly situated. Have they been promoted, or was there an process taken up,
But
and
promotion,
who has been promoted in the
as
meantime?
far as the promotion is concerned, my lord, as and when the vacancy is arisen, my lord, apart from the procedure in which vacancies are to be filled up, because only a certain percentage will be through promotion, my lord. A major percentage of the post will be through direct recruitment.
True.
So, my lord, I am sure the department has taken steps, my lord. Of course, this is, my lord, is subject matter in.
Mr. Bhattacharjee, you do one thing. You find out.
My lord.
File an affidavit. Let's, like I said, the court will not, may rely on it, may not rely on it, but let's take the basis as 2016.
My lord.
From there on, you inform the court or place before the court materials which will show when the process of promotion was carried out, who are the personal or let's put it this way, colleagues of the petitioner who were at the same post at that relevant point of time, and whether some of them have been promoted prior to that or after that, considering the stage of the petitioner.
But there is another aspect also, my lord, where there is no scope of promotion. Where there is no scope of promotion, my lord, the ACP and MSCP will come. The assured career progression.
That of course.
That will come.
That will come.
So even assuming that there is a situation that there was no promotion.
Yes. No. We are not talking about that. See, we are not talking about that. What this court would like to know is, as on 2016, when her appointment is deemed to have been confirmed, as on that date, she would have been equally situated with some other personnel who are functioning in the same post. Perhaps even in the same department.
In terms of seniority, my lord, she'll be.
So from there on till today, how many promotions have been made? How many of them are either junior or senior to the petitioner?
My lord, as far as the determination of seniority, my lord, the government instructions are also there, where maybe next date, but nevertheless, I'll just read, my lord. The matter regarding determination and fixation of seniority in respect of persons appointed on compassionate ground has been engaging the attention of the government for some time past. After careful examination, government have decided that seniority in all cases of appointment made on compassionate ground should be determined from the date of joining the post, and the position of the incumbent should be next to junior most in the cadre post on the date. Nevertheless, my lord, the petitioner will be junior in the. If there is a query from this honorable court, then I'll try and find out, my lord, as far as the promotion is concerned.
Please do. That would clear the picture as to whether she is entitled to be promoted, at which stage, in which year, because one of the grievance of the petitioner is that she has not been promoted till date. As far as the her appointment prior to 2016, that is a different matter. The court will deal with it based on the basis of the submission and the argument made, as well as on the materials on record. But as far as post 2016, the situation may be spelled out. We'll look into that, Mr. If you are entitled to, then you will be entitled to. As far as promotion is concerned, seniority is concerned.
Lordship, at least, Lordship, ACPS should be granted. ACPS.
My lord, even as far as ACPS is concerned, my lord, only thing is that, my lord, there is a petition pending. Perhaps this is the hurdle, my lord. Otherwise, but nevertheless, I'll seek instructions from the department, my lord. If she is entitled, she'll get it, my lord.
That's what, in fact, this court, time and again, this court has requested the respondent to look into the case and see if she's entitled, then it should be given to her.
Exactly why, my lord, considering the situation, department has at least considered her compassionate appointment. It is not a case that department has rejected, has terminated. Had it been terminated, then even then, whether petitioner would have had any right.
She was appointed after the death of her mother, who was serving at that point of time.
But as far as your pay scale is concerned, perhaps there may not have been any upgradation, but you have been, given due increment from time to time.
So increments there, Lordship.
That is, of course, that has to be. So please find out. 1 week's time. 2018 matter.
Sometimes it takes time from the department. I'll prefer 2 weeks so that I don't have to again ask it.
Heard and counsel for the parties. In the midst of the hearing, particularly on the submission made by the Leonard GA, query has fallen from this court as to the status of the petitioner post 21/3/2016 vis-a-vis any entitlement to promotion or upgradation in the form of grant of, now I think it's MSCP, isn't it?
MSCP, ACP.
ACP/MSCP scheme. The Leonard GA has submitted that instruction would be sought for and some time may be allowed for the same to be placed before this court by way of an additional affidavit. As prayed for, this is matter to 2 weeks.
Obliged.
Item number 12.
May I please, Your Lordship, that the conducting counsel is out of station, Your Lordship. That the matter may come after 1 week, Your Lordship.
I think this matter was heard, isn't it?
It was heard, Lordship. I have produced the material exhibits.
Yeah. So what is left?
Visa.
Yeah, what is left now?
Now, Lordship, yes, this is a
You want
conviction
his
against conviction.
No, it's contesting that.
Yes, I pointed out, Lordship, in the visa also the second extension is not genuine, it's fake. There's no extension number. The seal is also fake.
Yes.
And the evidence also are there.
Okay.
FSL expert has been examined.
1 week.
Yes, Your Lordship.
Prayer has been made on behalf of the petitioner seeking adjournment on the ground that the learned conducting counsel is out of station and could not be present in court today. On consideration of the prayer made, the same is allowed. As submitted, list this matter to 1 week.
Can you bless Your Lordship?
Item number 13.
Please, Your Lordship. Lordship, I pray for 1 more week, Lordship, in this matter.
On prayer made by the appellant, list this matter for 3 weeks.
Item number 14.
Excuse me. Yes, where were we?
My lord, this is yes.
Oh, no, there is no question of settlement here, isn't it? Or
My lord, there's no question of settlement in the sense that, my lord, actually this is only for the purpose of construction of a gate.
yes, yes.
By which both the parties are using the road to enter into their land. So the only issue here, my lord, is that the application injunction which has been obtained by the respondent, my lord, in this case, has been filed in my suit. And a suit filed by me was under section 77 of the Registration Act 1908, my lord. So, my lord, as far as the suit is concerned, the suit is an exclusive remedy for exclusive remedy. The prayer which have been prayed by me before the learned trial court is to allow me to register the sale deed, which has been executed by me and the father of the former respondent number 4, my lord. So on that suit, my lord, the respondent had filed a application, my lord. It's not a specific.
No, I think we are stuck on the appearance of the respondent 4, isn't it? Oh, yeah, there. Yes,
So the only law point, my lord, is that whether a suit filed by me under section 77, which is with an exclusive remedy, whether injunction can be granted in that suit, my lord. That's the only point, my lord. And that too, the proposed construction of the gate is on the land in my land, which is not in dispute, my lord.
Okay.
So this the place where the proposed gate is supposed to be erected, that is on the land which has already been purchased by my deceased husband way back in 1997, my lord.
Is there a dispute to that title?
No, my lord. Only dispute, as far as the dispute is concerned, is for a portion of the land which is behind my land, my lord. There is already an ejectment suit to that regard, my lord. So basically, the only law point which your lordship, in my respectful submission, my lord, to decide whether a suit under section 77, whether an application under order 39 rule 1 and 2 will be maintainable or not, my lord. That's it, my lord. That is the only point, my lord.
Yes, sir.
My lord, it's not as simple as that, because in this particular case, the Honorable High Court also has already passed an order long time back that the matter will be heard together. It is not only for that. It is there are many aspects also. It is TS number 11T97, which is a suit for recovery of possession, and the TS number 236T of 2013 under section 77 of the Indian Registration Act 1908 is to be heard together as per decision of the Honorable High Court, since in my show cause I've given in page 28, my lord.
That we are not disputing, my lord. That's a matter of
it is not like that, partly like that.
No, my lord. I am before your lordship being aggrieved by the order, the injunction order which has been made absolute by the trial court, my lord. I am before your lordship against that order, my lord. If you went and filed an appeal against that order from the London trial court before the lower appellate court, that was upheld by the lower appellate court, my lord. So the only issue before your lordship is that whether a suit filed by me under section 77, whether an application under order 39 rule 1 and 2 is maintainable or not, my lord. The law says no, because section 77, as far as I am concerned, my lord, my suit is concerned, this is for exclusive remedy. It's not a comprehensive suit or not a suit for specific performance. In a suit of specific performance or a comprehensive suit, that would definitely be allowed, my lord, but not in a proceeding under section 77 of the Registration Act, whereby my prayer is for exclusive remedy with regard to registration of only the sale deed, my lord. So that's the only point, my lord.
So the respondent is the respondent a party to your application?
My lord. Well, they have filed the application, my lord, in my suit, my lord. The respondent filed a miscase.
No, when you had filed an application under section 77, was the respondent herein a party therein?
Yes, ma'am. They are performer defendant, my lord.
Performer defendant. Oh, okay. So
only become regular defendant.
Okay, so they become regular.
My lord.
Once they contested the matter, then they become.
Yes, ma'am. So the miscase which has been filed and the injunction which has been granted is on the basis of the miscase filed by the respondent in my suit. So we have raised that issue before the trial court also regarding the maintainability of the miscase as to whether a miscase under Order 39 Rule 1 and 2 is maintainable in a suit under Section 77 of the Registration Act. In my respectful submission, my lord, the application which has been filed by the respondent, my lord, before the trial court for injunction is not maintainable, my lord. That objection which was raised by me before the trial court, before the lower appellate court, my lord, that has not been dealt with by both the two courts, my lord. So I'll just, my lord, I'll just brief your lordship. If your lordship can you take civil revision number 10, my lord, because the civil revision number 1, my lord, is the outcome of civil revision number.
Yes.
Well, the brief fact is that the husband of the petitioner herein and the deceased father, the deceased husband of the petitioner, as well as the deceased father of the respondent, pro forma respondent number 4, my lord, had instituted a suit way back in 2013, being title suit number 236 against the pro forma respondent number 5, who is the registrar, who had refused to register the sale deed, which was executed by my deceased husband and the deceased father of the pro forma respondent number 4, my lord, on the ground that an objection has been put by the respondent number, the husband of the respondent number 1, she ought to expire, my lord, bring dependency of the. So the father of the respondent number 2 and 3, my lord. On the objection of the father of the respondent number 2, number 3, the registration was denied. Against that, my lord, I have instituted, my husband has instituted, along with the father of the respondent number 4, my lord, had instituted the suit which was registered as title suit number 236 of 2013 against the pro forma respondent number 5, who is the registrar, my lord. My lord, the suit, lordship, your lordship will find that annexure 1, my lord. Page 17, my lord. Well, we'll see in the annexure 1, first page itself, 17A, my lord. Sued under Section 77 of the Indian Registration Act 1908, praying for a decree, for a direction to the defendant, that is the registrar, my lord,
Yes.
to complete the registration formalities of the sale deed dated 17/11/2000 executed between the plaintiff number 1 and plaintiff number 2 in the office of the registrar, East Khasi District, Meghalaya. So this is the suit, filed by the deceased father of the respondent, pro forma respondent number 4, and my deceased husband, my lord. My lord will kindly come to the prayer, my lord. That ownership will find at page 25, my lord.
Page
25.
25.
Page 25, my lord. Prayer, my lord. In the premises opposite, it is stated that your honor may be pleased to direct the defendant to register the sale deed dated 17/11/2000 pertaining to the land mentioned in Schedule B of this plane which has been purchased by the plaintiff number 2 from the plaintiff number 1 and or may pass such further order or orders as your owner may deem fit and proper. So, my lord, if your lordship see the plane or the suit which has been filed by me before the learned trial court, my lord, this is a suit for exclusive remedy, my lord, specifically for registering the sale deed which has been executed by my deceased husband and the father of the respondent number, the pro forma respondent number 4. My lord, as far as the injunction which has been granted in favor of the respondent, my lord, whereby I have been injuncted from erecting any gate in the land, my lord, that land is not disputed, my lord. That land, my lord, has been purchased by my deceased husband way back in 4/6/1997, my lord. That your lordship will find at Annexure 12, page 4, my lord. In my affidavit bringing on record, my lord.
Each
Affidavit bringing on record, my lord.
affidavit dated
Bringing on record, affidavit dated 25th April, my lord, 2022, my lord. File on 10th May.
25th April.
File on 10th May, my lord. Affidavit bring on record, registered sale deed, so and so, sale
Yes.
so and so. So, my lord,
Yes.
the land over which the gate was proposed to be erected, my lord, that land falls within this land which has been purchased by my deceased husband. This, after the death of my husband, this was subsequently mutated into my name, or I have transferred the entire, as far as the ownership is concerned, my lord, that has been transferred into my name, my lord. There is no dispute at all as in respect to this land, as far as this land is concerned, my lord.
Yes.
So the gate which was proposed to be erected by me, my lord, is on the front side of the entrance through my land, my lord. It will be more clearer, my lord, if your lordship see at page 21, annexure 15 series, my lord,
21
of the same affidavit, the photograph which have been. So my lord will see there is a this is the entrance, my lord.
Yes. Yes.
Post has been erected, my lord. So after the injunction order, my lord, we have stopped the entire construction, my lord. This land, my lord, is not under dispute, my lord. There's no litigation as far as this land is concerned, my lord. My lord will kindly see the next photograph, my lord, which will be more clearer, my lord. My lord, the first page, this is the entrance, my lord.
Yes.
See the next page, my lord, photograph showing the pillars of the proposed gate, page 22, my lord.
Yes.
This is where I had proposed to erect the gate, my lord.
Yes.
And page 23, my lord will see on the left hand side is a building. This is a newly constructed building, my lord. This was constructed during the pre-pandemic, my lord. So the only dispute, my lord, as far as the dispute is concerned, is with regard to the old house, my lord. If your lordship see on the left hand side, there's a gate at page 23. The disputed land is, my lord, the one where ahead, my lord, if you see, your lordship will see this Assam type 2-story building, my lord.
Yes.
That is the land which is under dispute, my lord, for which ejectment suit has already been filed. The respondent, my lord, are in possession of this particular. We are not disputing that, my lord. So that suit is still pending, my lord, for ejectment. That has been filed by the father of the pro forma respondent number 4, my lord.
Okay.
So in as far as the land where the gate is proposed to be erected, my lord, there is no dispute, my lord. So that aspect also was not taken into consideration by the trial court, my lord. So, my lord, what had happened is that during the pendency of the trial suit number 236, that is with regard to the registration, my lord, the suit filed by me, my lord, the respondent had filed a missed case for injunction, my lord. That, my lord, will find at page 63, my lord.
63?
Page 63 of the civil division, my lord. My lord, this missed case 90T of 2017, this was filed in my suit, my lord. Miss case number 19T of 2017.
Yes. Yes.
This has been filed in title suit number 236 of 2013, my lord.
Yes.
So what are they praying for? That your lordship will find at page 64, my lord. An application, page 64, no? An application under Order 39 Rule 1 and 2, read with Section 151 of CPC for ad interim injunction, order restraining the opposite parties or persons, agents or associates acting on their behalf or under their instruction from digging the earth and not to install erect any gate at the main entrance of the path toward the compound and house of the applicant. My lord could see that this is a very clear-cut prayer which they have made, my lord. So the gate, as I've stated earlier, my lord, is proposed to be constructed by me in the entrance of my land, my lord. No doubt, my lord, the path which is used by both of us, my lord, will lead to both to my house as well as the house which is under the occupation of the respondent, my lord. My lord, on the basis of this application, my lord, the learned trial court was pleased to pass an interim injunction on 24th August 2017, my lord. That your lordship will find at page 70. I'll read only the operative part, my lord, of the order.
Yes.
From page 75, my lord. Heard senior advocate impress upon the point that the case being sub judice, the right and title is yet to be decided by the order and on the first of the record. There has been a clear intrusion and obstruction by the opposite party, particularly the opposite party number 3, by digging the hole on the footpath in the very illegal manner. I have perused the application and the annexures thereto, including the map and schedule of the property in particular. It appears that there is a prima facie case in favor of the applicants. Moreover, the balance of evidence is tilted in their favor, as no inconvenience would be caused to the opposite party if her construction is restrained. Also, irreparable loss will be caused if the applicants are not granted injunction, as the act of those opposite parties will do untold damage to their right of way over the path. It has also been stressed that the opposite party number 3, if not restrained immediately, there is every likelihood that the construction of a fence or boundary wall or gate would be completed at the earliest and defeat the right of the applicants. Considering the urgency of the matter for the reasons discussed above, this court hereby grants ex parte ad interim injunction in favor of the applicants. The opposite party and the opposite party number 3 in particular, along with her agents and or any person acting on her behalf, is hereby restrained from illegally digging the earth at entrance of the main road or to construct, install, erect a gate, thereby obstructing, disturbing the right of way for egress and ingress of the applicant and her family members to their compound or house. For the opposite party number 3 is restrained from doing illegal acts which lead to changing, altering the nature of the character and position of the suit and till final disposal of the pending suit. But in my respectful submission, my lord, the order which has been, if your lordship kindly see the what is the last paragraph, my lord. I'll just read it again, my lord. 3-4 lines before the. Further, the opposite party number 3 is restrained from doing illegal acts which lead to changing, altering the nature of the character and possession of the suit land until final disposal of the pending suit. My lord, as far as this is the same suit, my lord, filed by me, as I've stated earlier, under section 77, my lord. So that this is for the exclusive prayer has been made by me only for the purpose of registration, my lord. So from this order itself shows clearly that, my lord, the trial court has not applied its mind, my lord, while granting the injunction, my lord, ad interim injunction. Subsequently, my lord, I had filed my show cause, raised the point of maintainability of the miscase number 90T, my lord. That was also not taken into consideration after the show cause filed by me. My lord, by order dated 30/10/2017, in Action 9, the interim order was made absolute, my lord.
Which?
It starts from page 86, my lord. I'll just read out the order. Page 87. CR put out for orders on hearing and show cause and the ad interim injunction granted in the instant miscellaneous application. Keeping in mind that such applications are to be disposed of within 30 days, this order is being passed irrespective of the outcome of the hearing on miscase 120 filed in the new suit bearing number 27T/2017. My lord, just to apprise your lordship, this is a new suit which has been filed by the respondent, my lord. This is title suit number 27T/2017 along with the miscase number 120T of 2000 for same cause of action, my lord. New suit filed by them, my lord. Same cause of action. That has been filed after a gap of almost 16 years, my lord. In the original suit, which has been filed for ejectment of the respondent, my lord, there has been no claim whatsoever as far as the path is concerned. There was no claim whatsoever by them. And all the annexures which has been enclosed in the miscase, they are not part of the pleading. Either in the title suit of ejectment, which has been renumbered as TS number 90/2013, which has been against the respondent, nor are the documents filed or the part of the pleadings in the suit filed by me, which is 236 of 2013. All the documents have been brought forward, my lord, only in this miscase, my lord. Learned Counsel Shri K.S. Kinjing, Senior Advocate for the applicant, submitted that the father of the plaintiff number 1 and defendant, both deceased, jointly purchased 2 properties measuring so and so. A part of which now forms the suit land at Lamkra Shalom. Both the fathers jointly constructed 2 houses on the above plot, and patta was obtained in the name of the Karta of the Hindu joint family with the plaintiff's father. It is contended that a family settlement was arrived at by the father of the plaintiff and defendant, whereby the suit land was divided among them, by which the plaintiff received the plot which with a single-storied house standing thereon, and the defendant received the plot with a double-storied house standing thereon. Then by way of a registered sale deed dated 4/6/1997, the plaintiff number 1, that is the father of the respondent number, performer respondent number 4, had sold of 11,187 square feet to one Gilbert Sunshine, that is my husband, my lord, deceased husband, who is now deceased and represented by his wife Srimati Helen Nakhar, plaintiff number 2, opposite party number 3, to this misapplication. It is also submitted that the above plaintiff number 1 has sought to also sell off the portion of the suit land which is in possession of the defendant, for which he had filed a suit for recovery or possession in TS 224T Ejectment TST of 2013. In the above sale deed, learned counsel pointed out that the portion of the land sold in schedule mentioned 129 south facing the Lamukra main road, learned counsel has relied on the document annexed to the plane of the instant suit, out of which the misapplication arises. It is also contended that the new TS 27T 2010 is being filed by them under compulsion to protect the right of easement and right of way of the applicants to the suit land. It is submitted that the approach road measuring 6 feet wide at the entrance near the public road and 10 feet wide at the edge of the suit land was never sold off to the opposite party, late husband, nor was its use by the applicants disturbed for 20 years up until now, when Srimati Helen Nakhar authorized construction of a gate on the approach road leading to the suit property. Learned counsel also questioned the safety aspect for the construction, as no FIR was ever filed to complain about the nuisance alleged by the opposite party number 3, nor does the latter have any right to dictate the terms by handing over the key of the gate to the applicant. What had happened is that, my lord, in our show cause, we have also offered, my lord, that if the gate is constructed, because both of us have to pass through that gate only, my lord, we have offered them that we will give them a key so that they can move in and move out any time of the day, my lord. That also they have rejected, my lord. In lieu of the above submission, learned counsel prayed for making the ad interim injunction absolute. Per contra, learned counsel Sri H.S. Thank senior advocate for the opposite parties questioned the act of the applicant defendant, submitting that they have not shown any documents that they have any semblance of title over the suit property. It is contended that the applicant have relied on measurement based on documents as far as 1934, which is practically not feasible. The defendant applicants have failed to bring on record that they have any title. There is no document to show even a whisper of title that they have not even filed any counterclaim. In the suit whereby the respondents, against the respondents for the ejectment, they have not filed even a counterclaim also. The points which have been raised by the respondent after 16 years, and as far as the road is concerned, that it's not part and parcel of the land which has been bought by my deceased husband. That is not a pleading, nor in the ejectment suit which has been filed against the respondent, nor in the suit which has been filed by me. And the documents I stated earlier, all the documents which has been brought in by way of this miscase number 19T of 2017, these are all new documents, they were not part of the pleadings of the respondent. In respect of the suit land behind the house of the plaintiff number 2, it is contended that the same was only in possession of the defendant as a caretaker by virtue of the caretaker instrument signed by the magistrate, copy annexed to the plain, and he was in illegal possession seeking to enlarge his domain. Hence, it is submitted that the suit for recovery is not a case of contesting titles. He also called approach road of 6 feet width near the public road is nothing but an imaginary path devised by the defendant and is not mentioned in any document whatsoever. Further, the area being frequented by local boys and car parked there illegally is a den of antisocial activities, for which learned counsel argued that opposite party number 3 has every right to exercise precaution and erect a gate at the entrance of her property, and she has been very kind as to offer a key to the defendant as well. In the light of his argument, learned counsel submit that application being filed for illegal gain deserves to be dismissed outright. Having heard arguments of both sides and on careful perusal of the report, it is observed that the plaintiff has annexed several documents to the plain, which has been relied upon by the defendant applicant. Annexure 9 of the plain is the indenture executed by Mrs. Ramola Bose in respect of the plot of land measuring about so-and-so, whereby the boundary has been shown so-and-so. Annexure 11, which is an instrument of lease executed by so-and-so, so-and-so, in respect of the above clause has clearly specified the distance of so-and-so, so-and-so. Moreover, the deed of conveyance by way of sale dated so-and-so clearly indicates the boundary sold to the plaintiff being so-and-so. Hence, going by the documents annexed by the plaintiff themselves, there is a prima facie indication that 6 feet of 6 feet of width of approach road near the public road was never sold to the plaintiff number 2. Well, on what basis the learned trial court has come to this observation or finding, my lord, that has not been specified. This is not even an issue in both the suit, my lord. Apparently, there was no dispute when the father of the plaintiff number 1 and defendant were alive. Further, for 2 decades, no issue had ever cropped up between the parties on the use of the defendants of this approach road until now, when the plaintiff number 2 tried to erect a gate at the entrance of the suit land. Irreparable loss would be caused to the defendant if the injunction is not granted, as their egress and ingress would be disturbed, since there appears no other road from which they can enter and exit the suit land. My lord, as I have stated earlier, my lord, this road is being used both by me as well as the respondent, my lord.
So that road belongs to whom?
That road belongs.
Is it a public path?
No, my lord. That is a road which belongs to the land which was purchased by my deceased husband, my lord. That is part and parcel of.
So in effect, it is your land,
my lord. That is no dispute. There's no dispute to that, my lord, and they are not disputing that my deceased.
But it is a thoroughfare to the property of the respondent.
My property as well as the property where they are staying, my lord. Okay. I have even constructed a new building, my lord. One building is in the front next to the road, my lord. This is where the RB store in Lamkra, my lord. One building is in the front, which is where the RB store is situated. One more building has been constructed by me behind, my lord. They have not put any objection when the construction was carried out by me, my lord. Because why, my lord? That land has been purchased by my deceased husband since 1997, my lord. So this road is part and parcel of the land which has been purchased by my husband, my lord. The only thing is that both me and the respondent are using the same road to enter into the premises. Clearly, irreparable loss and harm would be caused to the defendant if the application is dismissed, more so as the issues are yet to be decided and evident in the main suit is yet to be adduced. The object, my lord, I would humbly submit, my lord, the learned trial court has not gone into the plain, my lord, which has been filed by me in this case, my lord, because this miscase has been filed in the title suit number 236T of 2030, which was filed by me for registration of the land which is behind the land which has been purchased by my deceased husband. The object party, plaintiff number 2, has sought to erect the gate without taking into consideration the fact that for 2 decades the approach road has been used and is still being used by the defendants. To offer handing over a key to the defendant would only put a further strain on the relationship between the disputing parties. If at all any nuisance by the public is sought to be prevented, the parties could have resorted to other means like putting a signage warning trespassers. There is also no obstruction to the plaintiff from putting barricade on the side of the property currently under her possession. Hence, at this juncture, without going into the merits of the case, it can be concluded that the balance of evidence is clearly in favor of the applicant. From the following discussion, ad interim injunction granted by order dated 24/8/2017 is made absolute. So, my lord, subsequently, after that, my lord, after this order was passed, we had preferred an appeal before the learned additional deputy commission, the lower appellate court. That appeal was registered as FEO number 8T of 2017, my lord. That you also will find at page 90. My lord, in the appeal which was filed by us before the Learned Appellate Court, my lord, same issue was raised by us, my lord, as to whether the miss case number 90T 2017,
Yes.
filed by the respondent herein, my lord, whether it's maintainable or not. So that challenge has been put by us also, my lord, on the grounds, my lord. My lord, even the trial court as well as the lower appellate court, my lord, has not dealt with this matter at all, my lord. My lord, by order dated 4th March 2022, annexure 11, page starts from page 101, my lord. My appeal was dismissed by the lower appellate court, my lord.
Yes.
My lord, if your lordship kindly come to page 110, 110.
One one zero.
Para 21, the last paragraph. That's my submission. It may be pointed out that during the course of hearing, Sri L. Karim, Learned Counsel as petitioner, opposite party number 3, argued that miss case under application order 39 rule 1 and 2 CPC filed by the respondent applicant is not maintainable as there is no specific pleadings, and that the connected title suit 236T 2013 was filed by the plaintiff under section 77 of the Registration Act 1908, praying for a decree for a direction to defendant to complete the registration formalities of the sale deed dated so and so. Learned Counsel for the petitioner, opposite party number 3, contended that the suit filed under section 77 of the Registration Act 1908 is not a general suit, but it is a specific suit where the trial court cannot entertain the miss case application under order 39 rule 1 and 2 filed by the performer defendant, as there is no counterclaim. So, my lord, we'll come to page 113, the findings of the learned trial court. Para 23. On perusal of the above order 39 rule 1 2 order 39 rule 1 CPC and the above decision of the Honorable High Court of Delhi, it is clear that defendant can move for an injunction against a plaintiff without the necessity to file counterclaim if the subject matter of dispute arise out of the plaintiff's cause of action or incidental to it. Furthermore, it is seen that there is no provision under the Registration Act 1908 which bars the defendant to file application under Order 39 Rule 1 CPC in a suit filed by the plaintiff under Section 77 of the Act. Then, my lord, furthermore, interesting, my lord, the learned appellate court below, my lord, this is the miss case which has been filed by the respondent, my lord, whereby injunction has been granted. If your lordship kindly come to page 114, paragraph 27. For the reasons stated above, paragraph 27, my lord, 114, I hold that the petitioner, opposite party number 3, failed to establish that the 3 ingredients noted above for grant of injunction are in her favor. My lord, we have never filed application under 30. That is the respondent which has filed it. My lord, without dealing even the lower appellate court, my lord, without dealing the question of maintainability of the miss case for injunction, as mechanically, my lord, dismiss the appeal filed by me, my lord. My lord, After that, my lord, we are before your lordship. Now, my lord, I would read section 77, my lord. Registration Act, what does it say? Because the entire issue before your lordship is section 77 of the Registration Act. Section 77. Suit in case of order of refusal by the registrar, where the registrar refuses to order the document to be registered under section 72 or section 76, any person claiming under such document or his representative, assign or agent may, within 30 days after making of the order of refusal, institute in the civil court within the local limits of whose original jurisdiction is situate the office in which the document is sought to be registered, a suit for a decree directing the document to be registered in such office if it is duly presented for registration within 30 days after passing of such decree. So, my lord, as I've indicated through my suit, my lord, the suit which has been filed by me, my lord, is under section 77 of the Registration Act, my lord, which is with an exclusive remedy, my lord, and not a comprehensive suit. So, my lord, in my respectful submission, my lord, any application under orders 39 rule 1 and 2 would not be maintainable, my lord. If I file a suit for specific performance or a suit for a comprehensive suit, my lord, then only it will be applicable, my lord. Then an application under 39 1 and 2 would be maintainable, my lord. In this case, since the suit filed by me is under section 77, which is for exclusive remedy for registration, and the miscase has been filed in my suit, my lord. So, in my respectful submission, my lord, is that the miscase for injunction is not maintainable. As such, the order which has been passed by the trial court, as well as the lower appellate court, my lord, will not stand in law, my lord. In view of the fact that the application or the miscase filed by respondent is not maintainable, my lord. My lord, I would these are very rare cases. This kind of cases very rare, goes up to the Supreme Court, my lord. So whatever I could get from other high courts, my lord, I'm relying on those citations, my lord. So, my lord, this is AIR 1970, Kerala 261, my lord. The relevant paragraph is, my lord, paragraph 8 and 9, my lord. This is in as far as section 77 is concerned, my lord. Quite a number of decisions they have tried to distinguish whether a miscase for injunction is maintainable or not. So, paragraph 8 and 9. I will read one.
Please.
This is to say, once a document is refused registration by the sub-registrar, he cannot accept it second time unless there is a direction by the registrar under section 75 or by a court under section 77. The problem posed before me is whether, to establish his right to have a document registered, the executee is bound to bring a suit under section 77, which he cannot do without resort to the various steps indicated in section 73 to 76 within the time prescribed by the various section, the suit itself being limited by the time stipulated in section 77(1), or whether he is entitled, without taking any of these steps, to institute a suit for a decree directing the document to be registered independently of the provision of Part 12 of Mullah Act in his books of the Indian Registration Act, sums up the legal position and the conflict of ruling in the following words. The lesser remedy provided by this section does not take away the larger remedy under the Specific Relief Act. It has been held that the High Court of Bombay, Madras and Rangoon, that a suit to compel registration, that is a suit for a decree directing the documents to be registered, is maintainable only under this section, and independently of this section, no such suit will lie. A different view has been taken by the High Court of Allahabad according to the transfer, but no appear before the registering officer and to admit execution in the case where registration is compulsory, where a person therefore execute a deed of transfer but fails to appear before the registering officer and to admit execution, a suit will lie for specific performance of the implied contract or to register, unless steps have been taken under the Registration Act for the registration of the deed and the sub-register has refused to register the deed. In the later case, it has been held that no such suit will lie because the express provision of section 71(2), by which it is enacted that no registering officer shall accept for registration a document so endorsed unless and until under the provision herein contained the document is directed to be registered. The word under provision of hereunder contained contemplates a reference to the registrar under section 72 or 73 as the case may be, an order of reversal by the registrar under section 76 and a suit under section 77. The learned author continues, in Calcutta it has been held that no suit lies to enforce registration independently of this section, but it has also been held that if a party executing a document refuses to admit execution, it is open to the other party to sue for specific performance of the contract to transfer the implied document. The later decision admits the unregistered convey as evidence of a contract, a procedure which was commended by the Privy Council in so and so, but which is sanctioned by the provision of added section 49 of the Act of 1929. The Madras High Court dismissed from the decision from this reason before the provision was enacted, but the Madras High Court still takes the same view in spite of the proviso. The Madhya Pradesh High Court also holds that the suit under this section, the only relief that a plaintiff can get is one of a decree directing the registration of the document. The Punjab High Court has held that a suit under this section can only lie when the registrar has refused under this section. Yeah, 1985 Allahabad 259. Relevant paragraph paragraph 12 and 13. I simply endorse that finding. Paragraph 12. Relevant paragraph is relevant paragraph 12 and 13. I simply endorse the finding that as I am supported in my view by Mathai Joseph Pakal versus Joseph reported the the earlier decision which I have placed it was observed at page 226. In the present case, a suit under section 77 will not be adequate to meet the needs of the plaintiff because he is seeking not merely the registration of the sale deed but also recovery of possession of man and man's profit, which is outside the purview of section 77. Therefore, I hold that the suit is not barred either by the provision of section 7 for the registration or for the reason that the party has not pursued his remedy under part 12 of the Registration Act. Moreover, he is entitled, if really there is a contract of sale in his favor, there is a question of fact yet to be educated upon, to enforce the implicit agreement to get a proper conveyance executed and registered. A suit for specific performance of agreement to register the document is maintainable. In the instant case, the relief for injunction and possession as sought in the suit are outside the purview of an action under section 77.
Yes.
Unless I file a case for specific performance, my lord, then only the application under order 39 1 and 2, rule 1 and 2 will be applicable, my lord. Lord, in this case also, my Lord, the Supreme Court has dealt with the scope of Section 77, saying that under Section 77 it is an exclusive remedy, my Lord.
What is the citation?
My Lord, the citation is, my Lord, I've just got it in this way only, my Lord. This is reported in the Supreme Court. Judgment dated 5/8/1999.
It would have been better for you to.
My Lord, we have tried to get any other whereby the citation has been included in any other. We couldn't get.
Should have been 1999 matter. Should have been reported.
We have not been able to track it, my Lord. It should have been reported actually, my Lord.
Anyway,
The page 3 and 4 is relevant, my Lord. The difference, last paragraph, my Lord. The difference of opinion amongst the various High Court on this aspect of the matter is that Section 77 of the Act, my Lord, the last paragraph, page 3, my Lord. Page 3, last paragraph, my Lord. My Lord, my Lord. The difference of opinion amongst the various High Court on this aspect of the matter is that Section 77 of the Act is a complete code in itself, providing for the enforcement of the right to get a document registered by filing a civil suit, which but for the special provision of that section would not be maintainable.
yes.
Several difficulties have been considered in this decision, such as when the time has expired since the date of the execution of the documents, whether there could be a decree to direct the sub-register to register the document. On the other hand, it has also been noticed that an agreement for transfer of property implies a contract not only to execute the deed of transfer but also to appear before the registering officer and to admit execution, thereby facilitating the registration of the document wherever it is compulsory. The provision of Specific Relief Act and the Registration Act may to a certain extent cover the same field, but so that one will not supersede the other. Where the stage indicated in Section 77 of the Act has reached and no other relief except for a direction for registration of the document is really asked for, Section 77 of the Act may be an exclusive remedy, my Lord. However, in other cases, it has no application inasmuch as a suit for specific performance is a wider aptitude and is primarily of one for enforcement of a contract and other consequential or further relief, my Lord. So the Apex Court also has stated that, my Lord, Section 77 is an exclusive remedy, my Lord. I have sued for an exclusive remedy for registration, my Lord. Specific Act, definitely, my Lord. The other aspect, whatever, my Lord, the other prayer can be prayed for, my Lord. As far as the scope and power, scope of Section 77 is concerned, my Lord, this has been reported in the case of Madras High Court, my Lord. Relevant paragraph is paragraph 12, my Lord.
This is also no citation there.
My Lord, this is
That's
2012 MWN Civil 63, my Lord. Madras High Court, my Lord. But the other one which I've cited earlier, the citation, my Lord, I'll try to find out whether it's been reported or not by name, my Lord. Para 12, my Lord. But I'll just read the head note, my lord. This is which has been covered for paragraph 12. Registration Act 1908, Section 77. Power of court, scope of. Civil court ought to do only what registering officer should and could have done. Court under Section 77 concerned with only two questions: whether document has been executed, whether requirements of law for registering documents have been complied with. Said question, if decided in favor, registration ought to be directed. Para 12, madam. Further, the learned law appellate could fail to see another vital aspect, that when Thumbuswamy, the son of first defendant, and one Nambian, who signed the document as one of the witnesses, were dead, obviously they could not be examined by the court. Therefore, their signatures properly compared by the trial court as stated above by comparing the signatures found in Exhibit A1 and A2. Overlooking this practical problem, the learned appellate court committed a serious error in failing to see that Exhibit 1 and 2 have been specifically proved by the comparing of the disputed signature in exercising of the power conferred under Section 73 of the Indian Evidence Act. In a suit under Section 77 of the Registration Act, the civil court has got to do only what the registering officer should and could have done under the power conferred on him by the Registration Act. The court should not be guided by the same consideration which guide the registrar in registering or refusing to register a document presented to him. Under Section 35 of the Registration Act, a registrar is bound to register a document if the ostensible executant admits his signature to the document. This is the admission of the execution referred to Section 35 of the Registration Act. If a person admitting his signature or thumb impression proves that he had signed it under a misapprehension, believing it to be a different kind of document from what it was, or that he was induced to sign the document as a result of a deception practiced upon him, and that he was therefore unaware of the real nature of the document, it is a ground for setting aside the document.
This is not relevant in your case.
Malad, this is only the scope, as far as the scope of Section 77 is concerned, Malad. What is the power of the court, Malad? So the Madras High Court, Malad, have stated that the scope is that just whether the requirement of the law is registration 1 and 2. That's as far as the scope of Section 77 is concerned. Malad, the same thing is which we have got is from the Karnataka High Court, Malad. This is a citation on a civil. We have tried to find out.
You have given them the list of dates or list of books.
List of books are only submitted now.
I've given you a copy. Have you given them a copy?
Copy I've supplied to them.
Okay.
Malad, this is from Karnataka High Court, Malad. Relevant paragraph.
Again, you see, this is also relevant.
Try to find out from the Karnataka High Court judgment, Malad. Otherwise, we have got it only in this manner, Malad. Because as I've stated earlier, Malad, these kind of cases are very rare, whereby like these kind of issues have been dealt by courts, Malad. Malad, the relevant paragraph is paragraph 5 and 6, Malad. An order of temporary injunction under Order Rule 1 of Order 39 of CPC is for the purpose of staying and preventing the waste, damaging, alienation, sale, removal.
Yes, sir. Paragraph
5, or causing injury to the plaintiff in relation to the property. The order of injunction may be discharged, varied, or set aside by recourse to Rule 4 of Order 39, and in an appeal under Rule 1R or of Order 39 of the CPC, or in an original petition therefore. The final so passed would hold the field until disposal of the suit, which would merge with the decree by eventually pass, and the same will bind on the parties thereafter. The judgment and so on so is one of such order. Malad, this is with regard to the merger of the order which was passed with the trial court to the the dismissal by the lower appellate court. Malad, what had happened is that in this case, in the civil revision number 1, the other civil division. Well, we had what they have done is that they have filed an application. They have filed an application for violation of the order, my lord. But by that time, my lord, the entire proceeding was before the lower appellate court, my lord. So the entire case record has been called for. In spite of that, the respondent had gone and filed an application for violation of junction, my lord, before the trial court. The entire matters was seized by the lower appellate court, my lord. This is with regard to the other revision, my lord, revision number 1, my lord. Now, my lord, the relevant paragraph, my lord, will be paragraph 28 and 29. An analysis of, my lord has got it.
Yes, 28 and 29.
28, 29. An analysis of section 77 of the Registration Act indicates that it can be evoked only to secure the relief of registration of document. Para 28, no? And not for a comprehensive suit for specifically enforcing the agreement by directing the defendant to register the sale deed and for possession. This is clear from so and so. The only question in this second appeal is whether the respondent are entitled to the relief of injunction on the basis of possession. In the circumstances stated above, I am of the opinion that the respondent have come to the court with unclean hands. They have deliberately suppressed the earlier suits, fearing that it would clearly show that the appellant was not cooperating with them for registration of the sale deed. The mere fact that they have managed to obtain mutation of their names in the revenue record cannot help them when this was effected only after the compulsory registration of the sale deed, consequent to the decree passed by the court in favor of the respondent. They have not chosen to get into the box, but they put their father into the box, who did not know anything about the factual aspect of the post contrary to that. My lord, this decision, my lord, the section 77 can be evoked only to secure relief of registration of documents. So this is my this also will cover my case, my lord. Then the other, this is the only one which I have got Supreme Court judgment apart from the one which has not been. So the relevant paragraph would be my 10 and 11.
10?
Para 10 and 11. The difference of opinion amongst the various High Court on this aspect of the matter is that Section 77 of the Act is a complete code in itself, providing for the enforcement of a right to get a document registered by the filing a civil suit, which, but for the special provision of the section, could not be maintainable. Several difficulties has been considered in this decision, such as when the time has expired since the date of execution of the document, whether there could be a decree or to direct the sub-register to register the document. On the other hand, it has also been noticed that an agreement for transfer of property implies a contract not only to execute the deed of transfer, but also to appear before the registering office and admit the execution, thereby facilitating the registration of the documents wherever it is compulsory. The provision of Specific Relief Act and the Registration Act may to a certain extent cover the same field, but so that one will not supersede the other. Where the stage indicated in Section 77 of the Act has reached and no other relief except a direction for registration of the document is really asked for, Section 77 of the Act may be exclusive remedy. However, in other cases, it has no application, inasmuch as a suit for specific performance is of wider aptitude and is primarily one for enforcing of the contract and other consequential or further relief. If a party is seeking not merely the registration of sale deed, but also recovery of possession and men's profit of possession, a suit under Section 7 is not an adequate remedy. So, my lord, in my respectful submission, my lord, the suit filed by me is for exclusive remedy, my lord. So, if that would be the case, my lord, the miss case number 90T filed by the respondent praying for injunction against me would not be maintainable, my lord. That's my first ground, my lord. Second ground, my lord, is that the portion where the gate is proposed to be erected, my lord, that land is not under dispute, or there's no litigation as far as that is concerned. So, my lord, the court could not have injuncted me from undertaking any activities in my land, which the respondent themselves have admitted that it is not part and parcel of the land which is under dispute, my lord. So, in my respectful submission, my lord, as the miss case number 19T of 2017, filed by respondent is not maintainable in law, the impugn order which has been passed by the learned lower court as well as the appellate court should be set aside and quashed.
Reply next day, my lord.
When?
Immediate.
How soon? How long? How soon? Up to you.
My senior, it's for my senior. In the meantime, we will see for any decision which.
Can you do also? Can you just file a written synopsis of your argument with the authorities and try to find the relevant citation?
But it's very
1
rare
minute,
case.
Mr. Kinji. Art, Mr. Al Kriam, learned counsel for the petitioner. The learned Mr. K.S. Kinji, learned counsel for the respondent 1. You're paying for respondent 1?
No, 2 and 3. One has already expired.
1, 2, 3.
For respondent,
Right now, 2, 3.
2, 3.
for respondent 2 and 3, I submitted that he will be allowed to reply on the next date. As prayed for, list this matter to. Can we do it on Monday or Tuesday, Mr.
Next
Kinji?
week.
Yes.
My senior. In the meantime, Monday is okay.
Okay.
Monday.
In the meantime, I'll file my written small gist of submission.
As prayed for, list this matter for further hearing on Monday, 24th.
Item number 16.
Yes.
Lordship, this matter may come up next week. Lordship has joint prayer by respond.
No.
Lordship, the conductor counsel correspondent 2 to 7 is also not available today, so we are making a joint request for this matter to be distributed.
Next week, Lordship.
That is the review petition, my lord, because the state government has not filed any affidavit also last time. So matter may be come on next
week,
next Monday, my lord, on 20.
We will hear it on Tuesday.
Okay.
On prayer made by the parties, list this matter on 25th.
No further time may be given, my lord. They are taking to continuously review.
Just ensure that.
Yes. Otherwise, they may allow me to join after that. Let them take how many years they want. Mercifully.
Fine.
Item number 17.
So this is the matter, my lord, where the notice for recovery was issued by the Employee State Insurance Corporation to the petitioner,
Yes.
saying that he is having an establishment somewhere at Moblai. And in our case, my lord, it is our case that there is no such establishment, my lord. So it appears to be a misplaced notice. So in the affidavit, they
But that would be a question of facts.
it's a question of fact. But what is in the affidavit? What has come out, my lord, is how they came to include that, so to say, establishment, so that they have issued the notice. What they have said is, my lord, that they have gone for a routine inspection or something like that, when they go for rounds, my lord. And on one of those occasions, certain people from the corporation has seen some people working at that particular, or my lord, who were there at that particular location, and notice was served to one of those people who were there, and on the basis of that, they have eventually, my lord, what it has all culminated into the recovery proceedings. Our case is, my lord, that it is a misconstrued notice, my lord, in as much as the land, my lord, which is in question, is a garage essentially. It's an open land, open garage, my lord, which is owned by a family member of the.
So it is not an establishment per se.
No, it is not an establishment. It is an open land. Some cars and all are held up there, my lord, owned by one of the family members of the petitioner. The petitioner, my lord, has numerous businesses and establishments across the state, and all these, there's never been an issue with these ESI or EPF or anything, my lord. Here, my lord, there was no such establishment in the name of the petitioner, no such establishment itself in that name. So, my lord, at the time of motion, my lord, the impugned notice was stayed. The bank has never appeared. My lord is there for because they are only to implement.
You are for?
Respondent number 1 to 3.
Who is respondent number?
That is the corporation, my lord.
Yes, I.
Here, my lord, the very peculiar case, why we have not gone to the lower court, my lord, is because in our humble submission, we cannot go to the lower court because neither are we the employer, neither are we any employee, and admittedly we are not the corporation itself. So there is no locus to go to the court, my lord. And this is a case where it's a very simple issue, my lord, that the establishment doesn't exist. The person in whose name the notice has been issued is not the proprietor of that establishment, which itself doesn't exist. So the question of recovery does not arise. That is the limited issue here, Lord. And they have, in their affidavit, it is not the case that we have applied for the registration and there was work going on. It is only that at the time of inspection, they found some people, they issued a notice, and we have never received because we never had any establishment there, or the petitioner, as far as the petitioner is concerned. And whoever from the family may or may not have received, nothing to do with the petitioner's corporation. And it's well known, my lord, he's a reputed businessman. There's no question of evading or any intention to evade. There is no establishment, my lord, in that name.
Yes, Miss, what do you have to say?
Please, Your Lordship. Your Lordship, actually, notice on the 22nd September 2015 has been sent to the petitioner, and on the 7th May 2019 to her, and there was no representation from their side, and they never came for the personal hearing, which was held on the 22nd 9 2015, and again another opportunity has been given to them on the 7th 5 2019, and there was no representation made against the proposed determination of contribution. An order on the Section 45A of the ESI Act, it passed on 10/6/2019 for a period within 5 years amounting to 69,719. And Your Honor, no appeal on the Section 45AA was preferred by the petitioner, and did not appeal against the order made for the contribution. The matter was referred to the recovery office later. Your Honor, the petitioner being aggrieved with the actions of the respondents, it should have been sought relief from the Employees Insurance Court, Your Honor, as provided in Section 75 of the ESI Act, Your Honor.
But firstly, let's get to the basic.
Yes, sir.
have you determined that the petitioner is having an establishment, number one?
Your Honor,
And that
all the actions made by the respondent were carried on according to the procedure, Honor.
Yes.
They have gone for inspection. Twice they have went for inspection, and they have met the manager.
Where is the inspection report?
Inspection report.
Lordship, I have the affidavit at page 2, my lord. Page 2 is the averment, my lord. The picture is clear from here, my lord. Kindly see.
Yes, Mr. Tell me.
Paragraph 4, page 2 is the averment.
Is it extra one, Your Lordship?
Page 7.
Page 7.
Yes.
And the manager also have saying there, Your Honor. Durga Dhar.
No, she is not the manager, my lord. Nowhere stated that she is the manager.
So see, here you have in your inspection observation, you say that I have visited your factory establishment.
Yes, sir.
So now the question arises as to whether the place you have visited is indeed a factory or an establishment. How do you determine that? What are the parameters, or what are the indication according to either the ESI Act or otherwise, that first you have to be clear that this is the establishment. Later on you may come to know that it was run by the petitioner or anybody for that matter. But once you have determined this issue, then the rest follows. But where is the prima facie satisfaction that this is a factory or establishment?
Your Lordship, Annex 3, we have sent a letter to the proprietor, Your Lordship.
Annexure?
17, Annex 3.
Yes, what does Annexure 3 says?
We have sent a letter to determine the contribution due. What?
So this is.
There was no representation or no during the hearing.
Yes, I can understand that. But what you have said here is, here in your Annex 3, it is a communication to determine the contribution of the employee and the employer. Now, you have missed the point. The point is, firstly, have you come to the finding for a fact that there is an establishment or a factory? What is the name of the said factory? There must have been some sort of registration or all those things.
Annex 2, Your Lordship, page 9.
Except 2.
We have sent a letter to.
Yes, what does Annexure 2 say?
They have for registration of employees of factories and establishment under Section 22 Act of the Act.
Have you replied to this, Mr. Dev?
No reply.
We have filed a rejoinder. My lord, if I
No
may
reply
just-
to this letter, Your Lordship.
Lordship, what has happened is they have come for an inspection. On that inspection, my lord, it appears that some person from the family of the petitioner was there. They asked for the records of the establishment, all the records, my lord. The person concerned who received the notice said that there are no records. So they have issued a notice, my lord, which is Annexure 1, just to refer to, that the attendance register, salary register, these are not produced. Why I say, my lord? Because it was never there. Thereafter, my lord, they issue the notice at Annexure 2, saying that we have come for inspection and your establishment appears to be an establishment under the Act. So you are requested to take immediate steps to register your employees, make the insurance policy, this and that, my lord. And all of these have been addressed to the address, which is, my lord, not related to the petitioner. It has been addressed to the address of the establishment, to MS Endhar Construction, which was never in existence. So we have never received it. Thereafter, my lord, they have also sent subsequent notices.
You see, you have not received this.
Not sure. Even they are not denying that I have not received it. There is no receipt. So thereafter, my lord, what has happened is they have proceeded with the contribution to determine the contribution. Pursuant to that determination of contribution, they have forwarded, it has, end of the day, my lord, it has culminated to the recovery proceeding. So it is not required for me to challenge the contribution per se, because it has culminated to the recovery and I have challenged the recovery. How, right from the beginning in the petition itself, my lord, I have stated that how I came to know about all this is because when the bank received the letter that your account is going to be frozen for this reason, that is when I have come to know that this entire thing is unfolded. I have sent a legal notice to them, my lord. Legal notice for clarification, not in a very strict manner, that this is what has happened. It appears that there is something has been misconstrued. So you kindly this is
Where is your legal notice?
Lordship, Lordship may have the petition at page 28. I'm sorry, my lord, page 27. Page 27, we have sent a letter, my lord. This is to the authorized officer, written by the petitioner, my lord, not as the proprietor of the establishment. He says, my lord, that I have received a letter for recovery of contribution under so-and-so section, claims of such amount against Shri so-and-so, principal employer of so-and-so, situated at so-and-so. In regard to the above recovery application, I would like to state that there is no factory or establishment existing in the name of such and such, in which the petitioner is the principal employer. Furthermore, the said property, that is so and so, does not belong to the petitioner, and no business activity is carried out by me in that property at the period covered by the application referred above. They have not replied, my lord. Then we have again resorted to a legal notice at page 28.
You have not replied to this letter.
It has been received, my lord. Lordship will find the receipt on the top right corner, my lord, at 23rd 8, received. Thereafter, my lord, we have sent a legal notice, again putting the same thing, my lord. This has also, Lordship will find the receipt at page 31. It is received with the seal, my lord.
Yes.
And in fact, even the bank, my lord, had not proceeded till the time we have approached.
So this was received at the bank?
By the bank as well, because the other office is in Guwahati, my lord. I believe they have received, but it's not. Here, my lord, what Lordship was inquiring, my lord, that how an establishment is brought under the ambit of this act. My lord, essentially what happens is, for it to be considered as a factory or establishment, there has to be 10 or more employees working at the same point of time. One of the conditions. My lord. The second condition is that those 10 employees or more than 10 employees have to be working in that establishment for the last 12 months, for the last 1 year. My lord. And some other conditions are also there. So in this case, my lord, there is nothing on record to show that there is an establishment in this place run by me. These are the number of employees. These persons have been working here for the last 12 months. That is why you are under this act. Nothing, my lord. All these notices have been issued to the address, which is not, my lord, related to me, concerning me. There is no receipt also, my lord. So, and why I am saying, my lord, that I cannot go to the ESI court, because I am not the employer.
You may not be the employer,
No,
but you have received communication from the ESI, so it is incumbent upon you to reply. Perhaps you have written this letter.
Yes.
To clarify your position.
Yes, madam. Thereafter, they have proceeded with the recovery, so we
But
have
then,
come to this court.
Yes. Then the reply should have been. You should have replied.
And why I say, my lord, under Section 75 of the ESI Act, that concerns dispute with regard to contribution. Here, it is not a question of dispute of contribution as to how much or how less.
Yes.
It is a case that the establishment was never there. So I cannot say that I am an employer of an establishment which does not exist. So I don't have the provision under 75 to go to the ESI court. Added with the fact that I had replied, I had also sent a legal notice. The bank has acted upon it. The Honorable Court has stayed the recovery proceedings. And my lord, that is the... And he is a my lord, well-established businessman. There is no reason to come with such a claim if it was not genuine. There's, my lord, hundreds of employees under his various establishments, and they are all covered under the ESI and the EPF and relevant. Here, my lord, this is I still say that it is a misconstrued, my lord. I'm not blaming anyone. It appears, my lord, that they had come for inspection. Some people were there. They said that it seems you're running an establishment. They said we don't have any records. They proceeded, my lord, one-sided. And there is no receipt that the petitioner has received any letter. Only the initial notice, my lord, which was referred, was received by one Miss Durkadhar, who happens to be a family member, not related to the businessman. And that cannot be. And in fact, even in that notice itself, my lord, it is stated that the prior intimation is to be given for an inspection, so that the persons can collect all their documents and all that, but nothing. They come for inspection, they issue the notice, they issue some more notices that you should do this, that. They go for recovery.
Yes, what else do you have to say?
Yes, Your Lordship. Your Lordship, I think opportunity has been given to them to come for personal hearing, to clarify and all, but nobody turned out. Nobody was present twice, and on the 22nd September 2015 and on the 7th May 2019. And thereafter, the ESI has proceeded with the recovery amount. Your Lordship, we will.
Yes.
What I would like to citations of Karuslam, versus the Union of India. Gauti High Court, regarding to PC 981, 2022, paragraph 4. Having gone through the provisions of the ESI Act 1948, it is noticed that
Where's the citation?
Mention the date and the cost, I think.
Okay.
WPC 981 of 2022.
Yes, it's here.
having gone through the provisions of ESI Act 1948, it is noticed that Section 74 of the Act has provided the Constitution notice of the Employees Insurance Court. Section 75 of the ESI Act 1940 has provided for the matters which can be decided by the Employees Insurance Court. The learned counsel for the parties are not in dispute that the issues raised in this petition can be decided by the ESI Court. It is seen that subsection 2 of Section 82 of the ESI Act has provided for an appeal to the High Court from an order of an Employees Insurance Court if it involves a substantial question of law. As there is a statutory remedy provided under Section 75 of the ESI Act to the petitioner against notice of demand dated 17/6/2021 and the prohibitory order dated 14/7/2021, the petitioner shall approach the ESI Court by way of an appropriate application. The proviso to Section 2B of Section 75 of the ESI Act has made a provision for waiver of reduction of the amount to be deposited under subsection 28. The provision has given the authority to the ESI Court for reason to be recorded in writing to make such waiver reduction of the amount. The petitioner is at liberty to make such a prayer for waiver a reduction of the amount with all supporting documents, and in the event such a prayer is made by the petitioner seeking waiver of reduction of the amount to be deposited before the High Court. The High Court shall consider the same in accordance with law and by taking into account the facts and circumstances contended by the petitioner. And Your Honor, in MS Valley, Assam Railway Employees Cooperative Association versus ESI, entering into the merits of the case, Section 75 of the ESI Act 1948 provides.
This is what you are referring to. You are referring to this case. What para? Yes.
Your Honor, in terms of provisions of Section 75,
No, what is the?
they are directed to approach the SI Court for redressal of the grievances, Your Honor. Because
No, but you have
Section
cited
75 and Your Honor, they can approach.
that. We are not talking about that. You have cited this decision. You have also noted down the para, but where is the? From which para are you reciting?
Third paragraph, Your Lordship.
Yes. Yes, please continue.
And Abu Sahab Court and Salas Bros versus Union of India, High Court of Tripura, paragraph 3, Your Lordship.
Yes. Please read.
In view view of the effective statutory remedy available to the petitioner, this court is not inclined to exercise its inherent jurisdiction on Article 226 of the Constitution, and at the same time considers appropriate that if the petitioner approaches to the competent court in Section 75 of the Act within 6 weeks from today, it shall be treated to be within limitation, and it is expected to decide the dispute after affording opportunity of hearing to the parties in accordance with law. If appropriate, Your Lordship, let the petitioner present the case before the appropriate forum, Your Lordship.
But what's the difficulty for you to,
We have the Act, my lord, because in all these cases, there is no dispute that the petitioners are registered under the Act, so they can obviously they have to, my lord. Here is my case that there is no such registered firm. There is no question of me being the proprietor of that firm. So I am disputing that these are all, my lord, based on the concession to be. Lordship may have the Act, my lord, ESI Act. The position will be clear, my lord. Lordship, I'll like to take your lordship to the definition of factory, my lord. Establishment has not been defined. They have defined it as factory, which is at clause 2, subclause 12, my lord.
Section?
Section 2, section 12, my lord. Definitions, factory.
Yes.
Lordship, there is no definition of establishment. They say it will be factory, my lord. Lordship will kindly have the definition, my lord. A factory,
yes,
means any premises, including the precincts thereof, whereon 10 or more persons are employed. So the first condition, my lord, as per the very definitions, that there has to be 10 or more persons employed.
Yes.
Or were employed on any day on the preceding 12 months. So 10 employees in the last 12 months, my lord. And in any part of which a manufacturing process is being carried on or is ordinarily so carried on, but does not include a mine and a railway station. So here, my lord, three conditions are there in very simple terms, my lord, that there has to be 10 or more employees. They have to be employees, they have to be 10 in number or more, my lord. They have to have had worked at that point of time or any time within the last 12 months. And that at that so-called factory, my lord, there has to be a manufacturing process that is ordinarily going on. None of these ingredients are fulfilled, my lord. There is nothing to show that there are 10 employees working from this date to this date. This is the process that is going on. This is what you are manufacturing, or this is what is going on in the establishment. Nothing, my lord. So the very definition is not fulfilled, lordship, which is why I am saying that this establishment was never there, my lord. Lordship may have section 75, which talks about the
recovery.
Lordship. No, let's say 75 is with regards to the jurisdiction of the ESI court, my lord.
Oh yes. No.
75 says matters to be decided by the employees insurance court.
Yes.
Lordship will see subclause 1 says if any question or dispute arises as to. So it is a objective criteria, my lord. Number A, whether any person is an employee, so we are not concerned with that, my lord. B is rate of wages, we are not concerned. 3 is rate of contribution, is also, my lord, neither here nor there. D, my lord, the person who is or was the principal employer in respect of any employee. It is our case that, my lord, we are not the principal employer of any employee. E, double E, F and G, my lord, are not very relevant. Then subsection 2, my lord, also says subject to the provisions of 2A, the following claims shall be decided by the ESI court. So they are having exclusive jurisdiction over these claims, my lord. Number A, my lord, is claim for recovery of contribution from a principal employer. Claim for recovery. Number 2, my lord, claim by a principal employer to recover contributions from any immediate employer. C has been omitted, my lord. D is a claim against the principal employer under 68. E is a claim under section 70 for recovery of the benefits if a person has received the benefits which they are not entitled to, and F is, my lord, any other recovery of any benefit. Here, my lord, I have not claimed for any recovery or for any waiver or for any deduction or for any dispute. My simple case here, my lord, is that the establishment which they are alleging to be an establishment under the Act is not an establishment under the Act because it does not meet the very definition, number one. And number two, my lord, it is my categorical submission that there is no such establishment in my name, in that name, my lord, and I am not the principal employer of any such establishment in that name because the establishment itself does not exist. So there is no question of a dispute between the employer and the employee, or with then therefore, my lord, the question of going to the ESI court may not arise, lordship, because those are with regards to disputes between essentially the employer, the employee, and the corporation, my lord. Here, none of these, as far as I am concerned, it's not. I don't have the right to go, my lord, because the moment I go, they will say that, see, you have come to the court, you're the employer, and I am not claiming for any. I'm not saying that the amount is not correct or you should waive it or this is the reason. That I am saying that it is entirely misconstrued, my lord.
You have any authority?
Lordship, on facts, my lord.
That's facts.
I'll try to, if I can file a written argument with authorities if required. Even on facts from these judgments, my lord, of course it's not disputed that the ESI court's very much there. But why I have come, in fact I have stated in my writ petition as well, that this is the reason, my lord, that I am not covered under 75. And all the judgments are, my lord, the genesis is that these are registered organizations or establishments under the Act, and they have claimed for whatever they have claimed, my lord. So they have been relegated to the...
Anything else?
Your Lordship,
and also I have communicated to them by way of a reply and as well as a legal notice.
I would like to refer annex it to Your Lordship, my affidavit, page 9. Paragraph 4, Your Lordship.
Paragraph?
Paragraph 4, Your Lordship.
Yes. It's not even clear.
Yes, Your Lordship, I'll read out, Your Lordship. On the basis of the particular in respect of your factory establishment submitted by you, the report of the inspection conducted by the insurance inspector who inspected your factory on
not
applicable date, your factory falls within the purview of section 212 of the Act with effect from 1/4/2012. Provisionally finally, in case, however, subsequent facts reveal that your factory was to be recoverable from a data prior to the date mentioned, you shall make yourself able to comply with the provisions of the Act of such earlier date. And Your Honor, allotted code also has been sent to them for communications. They have registered before the ESI.
What it says is, on the basis of the particulars in respect of the establishment submitted by you is not the petitioner, it is that person who has received the notice, which is not the petitioner, my lord. And in fact, it is clear from the language that they had inspected the factory on an undated date, and thereafter they have found that they have. So essentially, what in my humble submission, if this is to be taken into accord, they should have issued this to me first, and then gone on to the coming for inspection. And what they have done is the reverse. They have come for the inspection. They have given a finding that I have not been able to produce the relevant records. They have proceeded on one hand with the contribution in the recovery, and then they come and give me the notice that we have done this, so you are required to give all this, my lord. And again, I submit, my lord, that paragraph 4 is neither here nor there, my lord, that when have they come for inspection is not applicable or not available. It was never submitted. I have never submitted any particulars. It was some family of member of mine, which I have said it's not disputed, and that person has nothing to do with an establishment. And finally they say that your factory falls within the purview of 212. And in fact, they are also not sure, my lord, with effect from 1/4/12 provisionally or finally, in case, however, subsequent facts reveal. So they are also not sure, my lord. Rightly or wrongly, they have come for an inspection. They have proceeded with, that is their duty, my lord. But
Yes,
on the facts, it appears that it's a misconstrued claim.
Anything else?
I am required to file my written argument, else lordship may pass.
Would you like to? How soon?
Authorities, my lord, I had looked for.
Not me. Not. It's up to you. I'm not saying that. I say you may have. You may not. Depends on you.
Give me 1 week. I'll try to place whatever is available.
So, Miss, you can also file the same if you want to. Or then a counsel for the parties. Hearing is concluded. However, it is the joint submission of the parties that joint submission of the learned counsel that the short written synopsis of the argument advanced today may be allowed to be filed in written form. As prayed for, this is matter to 1 week.
Much obliged.
Item number 18.
Really?
May I please your lordship? Since at that time my colleague was not there, so I would like again advance my submissions before your lordship, so that my colleague may kindly have a look into it. Lordship, I'll take your lordship first to annexation number 1, page number 15, which was in fact the FIR. Although lordship, I am submitting before lordship that I am not arguing on the merit. I will not take much of the time. Basically, lordship, I am arguing today on the length of detention and on the fact that all the accused persons has already been arrested. Statement of the informant has already been recorded. Lordship, my humble submission before your lordship is perhaps this is a case where 307 will not be attracted. Lordship, kindly have a look, lordship, in page number 15, annexation number 1, that is the FIR. I just read out very slowly. Lordship will be able to make out that this is an FIR which is in fact been made out. With due respect, I, the below signed informant, would like to state that on dates and times are very important here, lordship. That on 21/1/2023, 7:30 p.m., we came to Riders Mania 23 event at Orchid Umiam Lake, organized by BOBMC. While registering at gate, out of 3%, we registered mine, one of our members, with the name Joydeep De. We happen to know that our registered gift goodie bag has been taken by the opponent party OP. Accordingly, we have registered and gone to the camp. While going towards the stage, OPs were sitting and drinking alcohol. Suddenly seeing us, Jumma Khan, that is the present petitioner lordship, attacked with big size wooden log on my head, and doing self-defense, I put my right hand and hit my forearms. And it was supported other 3 persons along with Jumma Khan. It is full attempt to murder me. If I pause here for a moment, lordship, then here will be 3 plus 1 will be 4 persons. But 6 persons has been arrested in this case, lordship. Accordingly, we thought we should talk, report with organizer, concerned authority for the legal support same night, that is 21/1/23, we met organizer, and it was for meeting on 22/1/23. Next day, 22/1/23 at 12 noon, we came for meeting, and it was directed by the concerned authority to leave the camp, all of us, along with opponent parties. Now, if this is the case, Lordship will kindly see, if he has received a hurt in his forearm, and he says that it is a case where his forearm broke, your Lordship, then definitely he cannot sustain his pain for a period of more than 12 hours. Because why I am submitting this, Lordship, from the prosecution document itself, he said that he was initially hit on 21/1/2023 at 7:30 p.m. and then he had a meeting on the next day, 21/1/23 at 12 noon. From 7:30 to 12 noon, no medical assistance. Nothing is in the FIR. Then Lordship will kindly see the third paragraph, which is highly contradictory. He says, here he has said in the second paragraph, last line, it was directed by the concerned authority, that means the organizer, to leave the camp for all of us along with opponent parties. That means on 22/1/23 at around 12 noon, all leaves. Now the third paragraph is highly manipulated. Seeing the large number of percent of the opponent parties, we decided to go back to hometown. Where from the question of large number came, Lordship. Only 6 numbers of percent has been arrested. After going to Silchar, Lordship, kindly have a note, Lordship, for medical treatment with X-ray, where it was revealed that my forearm has been broken. Now, this appears to be a little bit imaginary, manipulated, concocted and fabricated. Because if a person, his forearm is broken, he cannot travel 299 kilometers without any medical assistance. Now, Lordship, what has actually happened? Why it triggered this fight? Lordship, kindly see, I have mentioned it in paragraph number 10, page number 8 of my bail petition. That the humble petitioner states that the humble petitioner has no whatsoever connection with the fight, as he was not present in the place of occurrence. I am taking a plea of alibi, Lordship. Although these are all matters to be decided during trial. The humble petitioner states that the informant and the witness of the informant were once upon a time a member of the Silchar Thumbers Club, Bullet Club at Silchar, Kacha, Assam, the motorcycle club in which the petitioner is a senior member. But because of the anti-club activity, the informant witness, namely Tonoy Paul, was removed from the club. And thereafter, said Tonoy Paul, along with the informant and another person, Joydeep De, the above mentioned person, in order to take revenge in the order to satisfy their ego, filed his instant FIR against the petitioner and his other friends. Furthermore, the informant had requested one accused, Robin Singha, to help him to purchase motorcycle, as because of bad CIBL score, CIBIL score, informant is not entitled to get any loan. And as the accused, Robin Singha, this is the actual fact that has happened, Lordship, is well settled, it will not be a problem to obtain a loan. And Robin Singha applied for a loan and the same was disbursed. And the informant only paid a down payment and was avoiding paying of the EMI to the bank. But the amount of EMIs were directly getting deducted from Robin Singha's account. And whenever the petitioner or his friend requested informant to clear EMIs, the informant gave negative response to the same. As a result, the internal politics of the said biking club, that is Silchar Thumbar Club, all the executive members along with the vice president Robin Singh and secretary Angshuman Dev, they are all arrested, Lordship. We have been roped into the affair, and as a result, they are behind the bars. Now, Lordship, will kindly have a look again to paragraph number 2, Lordship. Not 2, I am very sorry, Lordship. 5. This part is important, why I am taking a plea of alibi, Lordship. The humble petitioner states and submit that on 21 and 22 January 23, Royal Enfield Riders Association of Meghalaya, RERM, organized one event, BOMBC, Brotherhoods of Bulleters Motorcycle Consortium, Rider Mini at Orchid Resort, Umiam. And according to the petitioner, along with his other friends, got also themselves registered for the event and reached Umiam at around 21st January around 4:30 p.m. Lordship, will kindly see, when I have travelled around 299 kilometers, I have reached around 4:30 p.m. Basically, I am very tired. That is what I have mentioned. And it was terribly cold. The petitioner and his friends were tired after riding the Silchar to the event directly and went inside their tents to get themselves warm and to take some rest, and only came out from their tents around 8:30 p.m. That is the dinner time, Lordship. And he is saying that the entire incident, if I take your Lordship to the FIR now, happened around 7:30 p.m. So the entire FIR, Lordship, is nothing but a fragment of imagination. And IO has, in a very hurried manner, caused the arrest. In this regard, Lordship, I am relying upon one citation of the Honorable Supreme Court. Here, Lordship, 307 and 325 and 34 IPC has been added. Lordship, if I may kindly submit, in order to make a case under 307, perhaps 325 will not be attracted, 326 may be attracted. But when there is a case under 325, that means the IO himself is also in the doubt that whether any grievous injury attracting 307 has been made out. 325 says, Lordship, whoever except in the case provided for by section 335 voluntarily causes grievous hurt shall be punished with an imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Now if that is the case, then notice under 41 was mandatory. But they wanted to avoid that part and they have incorporated 307 and has arrested us. Lordship, I am coming to paragraph number 39, Lordship. I am having some sore throat, I am very sorry, Lordship. Paragraph number 39, if I may just read it out, Lordship. It has been held by the court in the Jagendar Kumar versus State of UP and others that no arrest can be made. Power to arrest is one thing and the justification for exercise of it is quite another. The police officer must be able to justify the arrest apart from his power to do so. Arrest and detention in police lockup of a person can cause incalculable harm to the reputation and self-esteem of a person. No arrest can be made out in a routine manner on a mere allegation of commission of an offence against a person. It would be prudent for a police officer in the interest of protection of the constitutional right of a citizen and perhaps in his own interest that no arrest should be made without reasonable satisfaction reached after some investigation as to the genuineness and bona fideness of the complaint and reasonable belief both as to the person's complicity and even as to the need to effect the arrest. Denying a person of his liberty is a serious matter. The recommendation of the police commissioner merely reflects that it was the fact of that case. There the police commissioner made an asked the police that you make an arrest. So there the Honorable Supreme Court is saying, Lordship, the recommendation of the police commissioner merely reflects the constitutional concomitance of the fundamental rights to the personal liberty and freedom. A person is not liable to arrest merely on the suspicion of complicity in an offence. There must be a reasonable justification in the opinion of the officer effecting the arrest that such arrest is necessary and justified. Except in heinous offence, an arrest must be avoided if a police officer issues notice to a person to attend the station house and not to leave station without permission would do. So here, Lordship, this is what Supreme Court says, that if he would have been called for, perhaps something would have been done. In the instant case, they have been arrested. The petitioner has been arrested straightforwardly. Lordship will kindly find his forwarding report in page 16, annexion number 2, 25-3, that is after 6 days. Because the FIR was registered, if I just take your Lordship once again to page number 15, FIR was lodged on 26/1/2023 on 10:15 p.m. It is there is a reflection of a note by the IO, and the incident happened at 21, that is after 6 days anyway. That's a different issue altogether. But it was 26/1 and he was arrested on 25/3. Lordship has kindly got it. Yes. So that is around a period of 3 months, 2 months. The arrest has been made, and that the CD will speak when the statement of the informant has been recorded.
Oh, he was arrested on
25/3, Lordship. Just a moment. 24 evening, night, he was picked up from his home, from Silchar, and the forwarding report says, Lordship, he was forwarded on 25/3/23. He was not taken for any remand. Any police remand was not sought for. From that day till today, he is behind the bar. Page number 16, if your Lordship has kindly got it, Lordship.
Page 16 is there.
Yes, Lordship.
Where's the indication that he has been?
His name is Jumma Khan, Lordship.
Where is the indication that he was arrested on 20?
Lordship will kindly see. May I just read it out, Lordship? To the Chief Judicial Magistrate, Nongpo Court, Riboy District, dated 25/3/2023. Now, Lordship, kindly come here, Lordship.
Yes.
Accordingly, the victim and the witness reported so and so, and he was arrested on the next date, page 17, Lordship. On 24/3/2023 PM, have been arrested in connection with the instant case and for the interest of the instant case. So, Lordship has kindly find it, Lordship. 1, 2, 3, third paragraph, Lordship. Last line of the third paragraph.
Okay.
Since then, he is behind the bar. Now, my submission as on today before Lordship, I am not submitting anything on the merit of this case. He is behind the bar today around 27 days, Lordship. Whatever may be the allegations, these are all matter of trials. And Lordship will kindly see that he is very sick. We have annexed some medical document, he is highly diabetic. And by this time, already the statement of the informant has been recorded. There, of course, the CD will speak. And all the accused persons who have been named has been arrested, Lordship. All are behind the bar. And 2 persons whose name were not there in the FIR, they has also been arrested, making it altogether 6 persons. My submission before Lordship will be that keeping him further behind the custody, maybe only a formalities may not be required for the interest of the investigation. So I would pray on any ground, Lordship.
Yes, Mr.
My lord, you have quite much the relevant documents, my lord, in the case diary, my lord. My lord can peruse it. However, my lord, it is at this stage, my lord, it is too much premature, my lord. My IO needs some more time for completing the investigation, my lord. It is the IO's right that if they are given sufficient time to complete the investigation, and if at all they make out a prima facie case, they will definitely file the charge sheet, my lord, in the matter. So at this stage, my lord, there is likelihood that in case the accused persons are released on bail and all, there may be a case of tampering and hampering with the investigation, my lord. So I pray that the bail may not be considered at this stage, my lord. My lord will kindly peruse the case diary, my lord. I have tried much the relevant documents and pass necessary orders.
Lordship, I appreciate the concern of the learned public prosecutor, but here I may submit one thing with all fairness. Supreme Court, Honorable Supreme Court, as well as High Court, as well as our own High Court, the Meghalaya High Court, in many judgment has came up that merely saying that it is a nascent stage of investigation will perhaps not do, Lordship, because they have to satisfy why it is a nascent stage of the investigation. Lordship, there are catena of judgment which says that when an accused is in a custody, every single moment counts. So whether in the case diary from 23/5 till today, the minutes of the details of the investigation done is recorded or not, Lordship will kindly have a look. Number.
I'll peruse this case diary.
Also, my lord. My lord, there is another case out of this same, it is not there, but then the case diary will be required for that case.
Let me tell.
So,
Lordship, what has happened? Out of this same FIR, as I submitted, the 6 accused persons has been arrested. Today this matter was taken up on my prayer before Lordship. That the Juma Khan, being an Islamic, his festival is on 22nd, and other matters are fixed on 26th. So I would pray if your Lordship may kindly retain the case diary, Lordship, because it will be required.
But yes. The PP for the other case will be Madam N.G. Sheila. So my lord, for her assistance, maybe at that time, relevant time, the courtmaster will hand it over back.
So that is why you see, Mr. Senguta, more often than not, you would notice that the court would not insist on the case diary in the original. A copy of it would also.
My lord, it's a voluminous case diary.
I think it is in duplicate.
No, 2 parts it is there. So,
it's in original?
So yes, that is why it is difficult for my office to Xerox and all. So I express
anyway,
my.
The case diary would be returned forthwith.
Yeah, sure.
So I'll pursue the.
Yes, ma'am.
I'll peruse the case diary and pass the orders. Thank you.
My only prayer is just to consider his length of detention is.
I've heard your submission. I'll pass the order.
Second call from Lady Costless. Item number 4.
It's almost 2. Shall we start after break? To launch permits or tomorrow? I will
We'll
not
take
take
it
a
up.
long time. It's a cover case also.
We'll take it up on Tuesday.
On Tuesday.
On submission made by the parties, list this matter on 25th. Either Monday or Tuesday, you choose the date.
Monday. We'll take it up.
Monday. Huh? Okay. Fine. Tuesday then.
State Commission submitted maybe at this way.
Thank you.
Item number 5.
Similar matter.
5 and 6 same.
Same matter. 4, 5. Same.
So 4, 5, 6 same, or only 5 and 6?
Well, only 4, 5.
Okay. What about this 4? 4 upon 4? No.
Number 4 and 5 same.
Huh? 4, 5, 6 same, or
No. Only 4, 5.
4, 5 is same?
6 we are not able.
No, wait, this is 4, 5.
Madam.
Okay, sorry. I thought 6. That. So, Tuesday.